ऑडियो दिख. हे नवीन नवीन हेडफोन लगा ना तू. हेलो वन. हे चिकवन. हेलो. एक स्लोगन बोलता हूँ मैं दूरदर्शन का, ठीक है. आता बूट कोर्सचा कार्यक्रम सुरू होत आहे. ये रे भाई. नमस्कार. नागपूर दूरदर्शन केंद्राच्या बँड 3 चॅनल 7 वरून आम्ही बोलत आहोत. थोड्याच वेळात GHRLC लॉ स्कूल यांचा बूटकोटच्या कार्यक्रमाला सुरुवात होत आहे.
Hello. Can anyone from the teams please switch on your mics? Any team? We just want to check that if we are clearly audible or not.
Yes, you are.
Yes, you are.
Yes, you
No
are.
disturbance at all.
No.
Thank you so much.
Proceeding forward, I would like to ask Pawde sir to felicitate our chief guest, Honorable Justice Shri Z.A. Haq. Now, I would like to request Sona ma'am to felicitate our guest of honor, Dr. Praveen Shrivastava. Now, now I would like to request our President, Rohan Kothari, to felicitate Director, sir. Now, I would like to request our General Secretary, Sudhanshu Rodkar, to felicitate Sona ma'am. We would also like to extend our warm welcome to the senior officer from MSBB Nagpur, Shri Deshmukh sir. I would like to ask Rohan sir to felicitate sir. A good education can change anyone. A good teacher can change everything. Dr. Sona Kumar completed her LLB from Dr. B.R. Ambedkar College of Law, Nagpur. In 1998, ma'am completed postgrad diploma in Human Resources Development, Chennai. In 2001, ma'am completed her LLM from RTM Nagpur University in 2001 and completed her second LLM for post-graduation in teaching from Nagpur University in 2006. Ma'am completed her PhD in law from Nagpur University in 2013. Ma'am is currently the principal of our esteemed institution. I would like to request ma'am to address everyone present here in the meeting.
Respected Honorable Justice Shri Zakahak sir, former judge, Nagpur bench, respected Dr. Praveen Shrivastava sir, respected Shri Sunil Raisoni ji, respected Director Dr. Ashok Pawde sir, invited guests, esteemed colleagues, teaching faculties, not teaching support staff, and my dear budding lawyers. On behalf of GHRLC Law College Nagpur and GHRLC University School of Law, Saikeda, I extend my privilege to welcome all the guests, all the dignitaries on the dais. From the inception of this college, the mock trial which we are beginning today is the part and parcel of this practical activity. It has been observed during years that this practice helps students in developing their mock and courtroom skills and also further enhance their personalities and abilities to work together under leadership. I quote Sean Allen, who stated, "Skill comes from consistent and deliberate practice." Therefore, students are reminded that building a practice of gratitude is the best way I know to create an optimistic approach towards life. Towards this, we are blessed with great limit to further. And therefore, once again, on behalf of GHRLC College of Law, Nagpur, and GHRLC University,
होते तर he won the ball. हे देख.
Hello, hello. Hello, mic check. Yes.
Now, I would like to request Ms. Amrita Oak to introduce our director, sir, to all of the participants present here in the ceremony.
Thank you, Nayan. A pessimist complains about the wind, an optimist tries to change it, and a leader adjusts the sails. With the optimism and leadership skills vested in him, I introduce to all of you the director of GHRLC Law College, Nagpur, Dr. Ashok Pawde, sir. Sir is a versatile personality, a renowned teacher, academician, and has enjoyed almost all reputed positions in the field of academics. Significantly, his post as a Dean of Faculty of Law in the Rashtrasant Tukaroji Maharaj Nagpur University. He has been the legal advisor to many legal educational institutions and is also associated with tremendous social work. He has worked as a civil judge at Prabhani. He was the head of the Department of Law at Yashwant Mahavidyalaya, Wardha. He had been selected for the lone post of Deputy Legislative Counsel in the Ministry of Law, Government of India. He is the permanent trustee of Maharogi Seva Samiti Dattapur, Wardha. A hardworking and a zealous person who supports the students with his entire will. I kindly request sir to address the teams and the students present here.
I'm extremely delighted to welcome on the dais Honorable Haq Sahib, former judge of Bombay High Court, and has been very good friend of mine. Honorable Shrivastava Sahib, who is a member secretary of Biodiversity, Government of India, and committed social worker and environmentalist, I can say. Whenever there is any threat to the environment, is always there. Our principal, Dr. Sona Kumar, my colleagues, dear participants sitting in this class, in this particular auditorium, and those who are watching from all over the India, because it's a national event, which I think it is directly telecasted also. Connected. 16 years are passed and we are now in 17th year. When we started Kshan, that time it was just a small child. And within the journey of 17 years, we got the national reputation. People are waiting for this event to come. And those who are participating are not participating from the small villages. The city like Bangalore, Delhi, Pune, Chennai, or from all the law colleges, from all these places, are vehemently joined in this particular event. When I look back, when myself and Akshay were practicing, or we were taking the education, we hardly any chance to participate in any event as an advocate. So only our journey started if any person had no legacy of advocacy, that was the senior's office. And even in those days, attorney was teaching that junior, that was the position. But days now are suddenly not absolutely changed today. Syllabus is changed today, and you are exposed to the practice right from your first semester. You have been taken to the courts. You have been you are forming the groups. You are actually giving aids in the form of legal aid to the different centers. So there is an exposure to your talent and your knowledge. And this is the platform. Because many times what happened, छोटे गांव का जज भी लेना था ना, तो उसके सामने जाने से डरते थे लोग. खड़े होने के शब्द नहीं निकलता था. मैंने देखा है जो जूनियर था ना, वो बात भी नहीं कर सकता, लेकिन those days have gone today. अच्छी बात यह है आपके जनरेशन की कि आपके पास अच्छा करेज है, जो हमारे पास नहीं था. क्यों है मालूम नहीं है, One of the good reason is that you are good in English. We may not be that much good in our time. That we honestly admit. Secondly, you also have the courage to speak the truth. But when speaking the truth is correct, comes now the entire debate starts. Whole debate starts from the speaking the truth. My dear students, your commitment as an advocate should always be towards the truth. Yes, you will be very honest to your client and you give your full assistance, you give your full, what I say, the knowledge, and don't give any chance to him anything. But your commitment should always be with the truth. That means you are accountable first of all to you yourself. Now, this platform which I am telling you is the platform giving you the voice for advocacy. Law has always said there is no end. If आज सबसे ज्यादा अर्नर कोई होगा ना पर डे वाला वो एडवोकेट ही है, और झाड़ के नीचे रहने वाला भी एडवोकेट ही है जो बेल के लिए तरसता है कि क्लाइंट कब आता है। आपको देखना है, आपको चुनना है कि वो झाड़ के नीचे रह के क्लाइंट को बुलाना है कि आगे देखना है। इट इज अप टू यू। और आपका अगर सपना बड़ा है, आपकी अगर उम्मीदें बड़ी है, तो डेफिनेटली आप अपना सपना चुन सकते हैं और रायसोनी वाले को डेफिनेटली चुन सकते हैं, बिल्कुल चुन सकते हैं। सवाल और भी है। सवाल क्या है? हम लीगल एड में काम करते हैं, लीगल एड में काम करते हैं, दौड़ दौड़ जाते हैं। मैंने तो हमेशा लोगों को बोला, अरे जब प्रैक्टिस करते हो, अगर एक वकील ने एवरी ईयर 1000 स्टूडेंट ऑलमोस्ट रजिस्टर्ड इन विदर्भ और मोर देन दैट, और उन्होंने कमिट किया कि भाई मैं एक केस में साल में फुकट करूंगा, पैसे ही नहीं लूंगा उससे, तो अपने को लीगल एड का काम ही नहीं करना पड़ता। लेकिन हाँ तो बोल लेते हैं, बाद की बात में उनका सीरियसनेस चला जाता है। ये एक पहली बात होगी। दूसरी बात यह है कि हमको गरीब लोगों की क्यों तो बहुत आती है, कहना तो बहुत आती है, हमें लगता है बेचारे के पास पैसे नहीं है, लेकिन आपके याद में प्रैक्टिस करते इंसानियत ऐसी मर जाती है कि वो होना नहीं चाहिए। पर्टिकुलरली मेरे स्टूडेंट्स तो बिल्कुल नहीं होना चाहिए। आप में कहीं तो भी एक जगह बना लो अपने दिल में कि नहीं, ये बंदा है, इसके पास पैसे नहीं, आज नहीं कल मिलेंगे, लेकिन इसके लिए मुझे झगड़ना है। वहां बात टूट जाती है, क्योंकि जो आदमी पीड़ित है ना सही मायने में, उसको अच्छा लॉयर कभी मिलता है, इसलिए नहीं मिलता है कि उसके पॉकेट में पैसे ही नहीं होते। और अगर आप केवल पैसे के लिए प्रैक्टिस करते होंगे ना, तो वो वकील को मैं कभी सैल्यूट ही नहीं करता, कभी नहीं करूंगा। पैसे तो वैसे भी आपको मिलना है, प्रैक्टिस जितने बड़े आप होंगे तो पैसे आपको फॉलो ही करेंगे। लेकिन
जो सिर्फ पैसे के लिए प्रैक्टिस करता है वकील है ही नहीं। आप समझते नहीं, ऐसा नहीं है। He is a businessman.
Absolutely, Lordship has absolutely pointed out that जो केवल पैसे के लिए काम करते हैं वकील है ही नहीं। मैं तो उनको दलाल बोलूंगा, उससे भी आगे जाके। You must distinguish between दलाल और वकील।
Sophisticated businessman.
बिल्कुल, आपको दलाल नहीं बनना है, आपको वकील बनना है। आपको कितनी फी लेनी है हम कभी नहीं बोलेंगे, इट डिपेंड्स ऑन यू, आप चार्ज कर सकते डिपेंडिंग द क्लाइंट। लेकिन एक क्लाइंट है जो टोटली रूइंड है, उससे क्या एक्सपेक्ट करते हैं? वो तो आपके लिए, आपके सर्विसेज के लिए भर रहा है, आपको उनको सर्विस देना है। यहाँ के अच्छे लूसिड लैंग्वेज में आप आपका परफॉर्म करेंगे, तालियां खींचेंगे, बड़े आप वकील हो जाएंगे, आपका नाम भी होगा। लेकिन नाम के साथ अगर आप इंसानियत भूलेंगे, इंसानियत सबसे बड़ी अहम है पूरे हमारे लाइफ में। हमारे लाइफ का पूरा जो बेसिक है ना, वो इंसानियत ही है। पैसा और इंसानियत अगर दोनों साथ साथ में चलेंगे ना, तो आपका लाइफ भी मीनिंगफुल हो जाएगा, सही में मीनिंगफुल हो जाएगा। मेरा एक्चुअली ये कहने का मुझे कोई कारण भी नहीं था, क्योंकि मुझे लगता है कि मेरा जब भी मुझे मौका मिले कि मेरे स्टूडेंट को मैं बोलूं, मैं देख नहीं सकता उन लोगों का, क्योंकि कितने अच्छे केसेस होते हैं। मैं जब एडवाइस करता हूँ ना, तो परफॉर्म ही नहीं होता दूसरे एंड से। सिविल केसेस में मोस्ट ऑफ द केसेस क्यों लूज करते मालूम है? केवल वकील की गलती के कारण। मैं आपको एक इंसिडेंट बताता, मेरे मतलब किसी का नाम नहीं लेता। एक सिविल कोर्ट ने गलत ऑर्डर पास किया, वो सिविल सूट एंटरटेन नहीं करना चाहिए था कि बॉम्बे पब्लिक ट्रस्ट एक्ट ने बार किया उसको, सूट एंटर किया, इंजेक्शन दिया, और वो मैनेजर आया और मैनेजर ने वो 15 दिन के अंदर सारा पूरा बजा दिया, वहां का सारे ओरिजिनल कागज चुरा लिए, क्या क्या गड़बड़ी करके रख दी। तो ये गलत, यानी कि यू सी एडमिनिस्ट्रेशन ऑफ जस्टिस में एक गलत ऑर्डर भी बहुत बड़ा नुकसान करता है। ड्यूटी एडवोकेट की भी होती है, ड्यूटी जजेस की भी होती है, ड्यूटी लोगों की भी होती है। ये थ्री फोल्ड ड्यूटी में एडमिनिस्ट्रेशन ऑफ जस्टिस चलता है। अगर जुडिशरी इनहांस होती है, जुडिशरी का रेपुटेशन बढ़ता है, तो आपके कारण बढ़ेगा। जो कॉन्फिडेंस, जो फेथ इंडियन जुडिशरी पे है, अभी भी है। थोड़ी देर के लिए मैं नहीं बोलूंगा कि लॉर्डशिप यहाँ बैठे हैं, हुआ है कुछ इंसिडेंसेस, किसी शेकन हुआ है उसमें हमारा कॉन्फिडेंस, लेकिन हम उसमें से नहीं है। हम उनके पार्टी नहीं बनना चाहते, हम उनके ही पार्टी बनना चाहते हैं जिसके कारण जुडिशरी की जो इमेज है बढ़े। आज इतनी स्ट्रॉन्ग जुडिशरी है, आई टेल यू, इंडियन जुडिशरी कंपेयर्ड विद द अमेरिकन जुडिशरी ना, 5 साल की पहले की बात बता रहा हूँ मैं। देयर आर सो मेनी इंस्टेंसेस, यानी कि फंडामेंटल राइट का जुरिस्प्रूडेंस इतना बढ़िया डेवलप किया, लेकिन कभी कभी लगता है कि केसेस केवल वो 4 शोभराज की, मेनका गांधी की, या और बड़े बड़े इनके ऊपर क्यों आते हैं? जो एक रूइन कलाकार है, यानी कि बेचारा सही में रिलीफ के लिए तड़पता रहता है, उसके बाजू में क्यों पीआईएल नहीं होती? और पीआईएल में भी हमने देखे कि जुनाइद पीआईएल कितने हैं, और दलाल वाली बात कर रहा हूँ, फिर से वही कर रहा हूँ कि वहां पे ब्लैकमेलिंग करने वाले भी पीआईएल वाले लोग हैं। पीआईएल के नाम पे पहले राइट टू इंफॉर्मेशन का वो दुरुपयोग करते हैं, बाद में पीआईएल का दुरुपयोग करते हैं। लेकिन जजेस लायक जो हफ्तार जैसे जजेस रहते हैं ना, बराबर देखते हैं, उनके नजर से छूटता नहीं है और वो रिलीफ बराबर देते हैं। तो एक ऐसा एक ऐसी सिस्टम है हमारे पास, एक जो पूरे सिस्टम, मतलब यहाँ की जो बिगाड़ है हमारे एडमिनिस्ट्रेशन का, उसको फाइट कर सकते हैं हम। और इतने अच्छे प्रोफेशन में आप आए हुए हो, एक अच्छा मौका है आज। एक ट्रायल कोर्ट का एक मूट कोर्ट कंपटीशन यहाँ पे है। मूट कोर्ट कंपटीशन 2 प्रकार की होती है, एक ट्रायल कोर्ट की मूट कोर्ट कंपटीशन होती है, और दूसरी होती है जो यूजुअली अपन हाई कोर्ट लेवल पे करते हैं। हमने ट्रायल कोर्ट की इसलिए किया है कि ट्रायल कोर्ट में ही आपका जो कस है, मतलब आपका जो टैलेंट है, वो रियली एक्सपोज होता है। अगर आप पूछेंगे, अफसर से भी पूछेंगे, तो आपको डेफिनेटली यही बोलेंगे, अगर प्रैक्टिस डिफिकल्ट कहीं की है ना, तो लोअर कोर्ट की। सबसे डिफिकल्ट क्या है कि एविडेंस लेना है। आप जब प्रैक्टिस करोगे ना, तो आपके समझ में आएगा हाउ डिफिकल्ट इट इज टू एग्जामिन द विटनेसेस। आर्गुमेंट ऑन द बेसिस ऑफ द डॉक्यूमेंट्स यू कैन मेक इट, आर्गुमेंट ऑन द बेसिस ऑफ द रेडीमेड केस लॉ यू कैन मेक इट, लेकिन केस बनाना बड़ी मुश्किल बात है। और केस तभी बनती है जब एविडेंस आप अच्छी तरह कलेक्ट करते हैं। और जबकि ये पूरे ट्रायल, क्रिमिनल ट्रायल है, एक रेप की केस है, एक इलिसिट रिलेशनशिप डेवलप की वो लड़की के साथ, उसके बाद उसके एक्सपोज हो गई, उसके बाद 376 का ऑफेंस हो गया। अब उसमें आप उसका स्टेटमेंट देखो, उसके बाद फॉरेंसिक रिपोर्ट देखो, डीएनए की टेस्ट देखो, डॉक्टर का एग्जामिनेशन देखो, ये सारी चीजें। और क्रिमिनल लॉ की है कि प्रोबेबिलिटी भी नहीं चलता क्रिमिनल लॉ, जो भी एविडेंस होता आता है वो बियॉन्ड डाउट प्रूव होना चाहिए। और 376 की केस क्यों ना हो, अगर 376 थोड़ा सा उसके लिए अपवाद भी है और स्ट्रिक्टली एविडेंस वहां पे थोड़ा सा ढीला हो जाता है, तो क्यों है, उसका भी रीजन आपके पास होना चाहिए। आर्टिकल 21 का उसके साथ क्या रिलेशन है वो भी देखना चाहिए। ये सारी चीजें आप एज ए पार्टिसिपेंट देखेंगे, सारी चीजें एज ए जो आप आज परफॉर्म करने वाले लोग हैं वो करेंगे। और मुझे पक्का विश्वास है आज का जो नेशनल एक अच्छा जिस तरह से चल रहा है हमारा, उतनी अच्छी तरह चलेगा और हमारा नाम इसमें आगे बढ़ेगा। इस बार इस 2 शब्द के साथ मेरे भाषण को मैं पूर्ण विराम देता हूँ। धन्यवाद।
Thank you, sir. Now I call upon Ms. Nayan Mirpuri for introducing Praveen sir to all of us.
We do not inherit Mother Earth and its bounty from our ancestors, we borrow it from our children. This is the intergenerational equity principle. Dr. Praveen Shrivastava holds the position of an IFS. He is the member secretary of MSBB and PCCF Nagpur. Sir has completed his LLB from Nagpur University. Sir attained his post-graduation in MSc Zoology from Delhi University in 1985. Sir has worked in Department, Government of India and UNDP sponsored PGPPM from 2004 to 2006 in Public Policy and Management, and Department of Government of India sponsored MA at TERI University, Delhi from 2011 to 2013. Now, I would like to request our guest of honors to address us.
Honorable Justice Shri GHRLC, Dr. Ashok, Pawde, Dr. Sona Kumar. I really feel privileged to be here amidst you on the event of Kshan, National Trial. To me, mooting is a judicious blend of art and science. Why do I call it art? Because it needs articulation, which may not be found clearly in books. Why do I call it science? Because you need to understand facts and link them with the law provisions. Also, it calls for some research because you have to buttress your arguments with the existing case laws. Therefore, it has, I think, three dimensions. It has an element of art, it has an element of science, and top of all, it has an element of research. But to me, beyond these three factors, still there is X factor. And this X factor is your instinctive response to a spontaneous query from a judge or from the opposite side counsel, which you may perhaps not anticipate, you may not foresee. It is here comes your real skill to really respond well and effectively to the question and the query. Teamwork, organized and methodical approach to lead all your arguments towards an acceptable conclusion is a very, very unique skill. And I'm sure which can be nurtured by the practice of moot courts alone. Trial court, be it of civil or criminal, I think gives the most insightful learning of CRPC and CPC to the students. Being exhaustive, intricate, and dealing with the law ground facts and application of law to them makes the exercise challenging as well as exciting. Here, intelligence and diligence both count, but surely diligence has lion's share, and it is the sheer diligence which in due course of time helps you to inculcate that intelligence which helps you in future profession. This moot court, I'm sure, would pave way to the young budding lawyers to blossom into seasoned and successful professional in years to come. Needless to state, Nagpur is a place which has witnessed legal luminaries like Shri Harish Salveji, our former Chief Justice Shri Sharad Bombay, Shri Bhushan Gawai. Certainly, this Nagpur city has got something unique, and so many others. Certainly, the city has something special, something there in its air and ambience, which has helped to produce such brilliant legal minds. I'm sure some who are sitting here, I'm sure would blossom into very successful and seasoned lawyer in days to come. I think it is very aptly said that bar and bench both contribute to raise the bar of efficiency of justice delivery system amidst all the challenges of soaring pending litigations, under-equipped infrastructure, and uncertain ecosystem of democratic governance. Last but not the least, it is in the conviction of young lawyers that there lies the destiny of future of society, especially when complexity of law is geometrically increasing with increased privatization, globalization, and pressure of sustainable development, and top of all, upsurge among people to see a just, free and fair society in days to come. Once again, I thank the institutions for giving me this opportunity to be amidst you and share some of my ideas with you. I extend my best wishes to all the participants and wish the best may win. Thank you so much.
Thank you, sir. Now I would like to request Ms. Amrita O to introduce Honorable Shri Justice Officer to all of us.
Thank you, Nayan. Justice consists not being neutral between right and wrong, but in finding out the right and upholding it whenever found against the wrong. Justice Haq is a visionary in his profession. Sir was born on 17th May 1959 and completed schooling from Holy Cross Convent High School, Akola. Sir graduated with a BSc degree from RLT College of Science, Akola, and LLB from the then Sitabai Arts College of Akola. Sir enrolled as an advocate with the Bar Council of Maharashtra and Goa on 15th January 1985 and started his legal practice at District Court of Akola with his father, Muhammad Azizul Haq sir. Sir shifted to Nagpur in the December month of the year 1985 and joined offices of Advocate Shri J.N. Sangolkar sir. Sir has also represented the Union of India as Additional Standing Counsel and the Government of Maharashtra as A Panel Counsel. Sir was elevated as an additional judge of the Bombay High Court on 21st June 2013 and then was elevated as a permanent judge at the Bombay High Court in 2014 and finally retired in 2021. I would like to share a very personal experience I had with Sir. A few days ago, when I went to invite Sir along with Shwetal Kothari, we were invited to his house so humbly and were greeted as if Sir has been knowing us for years and years. We were very shy at first, I would definitely admit that, but as soon as Sir started talking to us, it did not feel like a justice of the Bombay High Court was talking to mere fourth-year law students. It is such a delight to have a person.
I was talking to you as my daughter.
Sir, it is a very huge honor to have you among us today. And now I request you to address us.
Respected and dear friends. Respected means the teachers present here and all others are covered by the term dear friends. Those on the dais and in the auditorium. A very good afternoon. I would like to share some incidents rather than give some speech, because some of my dear friends sitting at the back chairs have already started yawning, thinking that now this judge will give a very boring speech. So I will avoid giving any sort of speech. I will share some incidents. The first thing I want to share with you is the advice which I received from my father, with whom I started practice. On first day, my father said, as a senior, not as father, प्रैक्टिस में दो चीज हरदम याद रखना. एक, जो पावड़े साहब ऑलरेडी बोल चुके हैं, पैसे के पीछे नहीं जाना. काम करते जाओ, पैसा तुम्हारे पीछे आएगा। दूसरा, never give assurance to your client that he has an excellent case. You may be sure that your client is bound to succeed. There are Supreme Court judgments in his favor, but still, never give assurance to your client, because you don't know by the time the case of your client is decided, the law laid down by Supreme Court itself may be overturned by larger bench of Appellate Court. So, and if you adhere to these two things and work sincerely, there is no reason why you should not succeed and why you should not be at this place addressing some gathering after 20-25 years. You will be there. I have always enjoyed coming to this program since Kshan, and prior to that when Moot Court started, I have always been a part of these programs, either in this college or Ambedkar College, University College, Jalgaon, Pune. At Pune, I have occasion to be a part of the panel for international moot court competitions, in which finalists were Bhopal and Kenya, and Kenya succeeded. They were the winners.
Despite the fact that Kenya is backward country.
That's what. And when I minutely looked at the team, I felt that the two boys who participated perhaps had occasion to wear blazer for the first time. They were very, very uncomfortable in their blazers. But they were the winners. This program gives, especially when you sit on the panel in the competition, I have experienced so good, so nice arguments, and really some arguments are of such points are raised that it is difficult to even think that such arguments can be made by a seasoned lawyer also. I don't know, some of you might be knowing one budding advocate, Kshan perhaps. She is practicing with Mr. Anil Mardikar, senior advocate. Her first appearance was before a bench of which I was a part. She started arguing, and typical in the fashion as argued in moot courts. I was sitting as a junior judge. My senior brother got disturbed. He repeatedly told her, please come to the point, please come to the point. Then I told my senior brother, sir, please wait, let me handle her.
Very nice.
And I permitted her to argue the way she wanted, and within 3-4 minutes, she was able to convince us. Even my senior brother was convinced. Then, after we signed the order, he asked me, why you were so confident that she has a good case? She was just leaving that first row after arguing. I called her back. From the dais, I asked her, from which college you have studied. She gave the name. Then second question I put to her was, how many moot court competitions you have participated in? She was looking at me. I again asked her, I told her that I know that you have participated in moot courts. I can gather it from the way you were arguing. Then she said yes, she was winner in some moot court competition also. Then I told my senior brother, this is what happens when you interact with the students in such programs. You know their depth. Otherwise, you take them as juniors. As Pawde sir said, you are far, far ahead than our generation. You are lucky to have that exposure. In our days, we were not having online facility of online engagements. There were limited number of journals, 3 or 4 journals, which we used to get after 15 days or a month. Now you get the Supreme Court judgments today evening online. That judgments are available to you. So that way you are very lucky, and you should exploit your luck and march ahead so that we can also feel proud of you. As far as practice part is concerned, again I am on the same point as Pawde sir has already said that difficult practice is in trial court. I will not say it is difficult. I will say it is more challenging. You have to prepare the case after taking instructions from the client. You have to yourself sort out what pleadings you should take and what should be avoided. In trial courts, it is very difficult to get the instructions, to get the documents, and to take out, most important, to take out fees from your client. Therefore, it is very difficult, but you should practice in trial court for at least 2 years. And it is not that I am saying it just for the sake of saying. My son is a lawyer. I forced him to practice in trial court for 2 years, and now he is practicing in High Court, and he is very happy because the confidence level of a lawyer who practices in trial court is totally different. His foundation is very strong. So if possible, don't directly jump to the High Court or Supreme Court. Have the experience of practicing in trial court. Try to conduct evidence. Try to see that how the documents are exhibited, how they are proved, how they are produced. Now, 2 cases which I have dealt as judge, I would like to share those incidents. In one case, the topic is on POCSO, therefore I am sharing these 2 cases just so that you can have an insight of the act from various angles. An appeal came before us in High Court. Minor girl was sexually abused by her father. Victim's mother lodged complaint against victim's father, means wife lodged complaint against her husband. Victim's mother gave evidence, victim gave evidence on the basis of which accused was convicted. He was sentenced for 5 years. Appeal came before us and application for suspension of sentence, grant of bail came before us. On seeing the facts, I was not inclined to grant bail because after grant of bail, accused was bound to stay in the same house where victim was residing. I thought that it would not be proper if he remains in jail for 4-5 years. The girl perhaps would get married and there will be no chance of both of them staying in the same house. But the girl and mother of the girl supported the accused. They said bail should be granted. And reason was they were from labor class. They said that he is the only earning member in our family. And after his conviction, there is no one to look after us. We are not able to have meals, and education of younger brother of victim was also over. He was not able to meet the expenses of schooling. We were faced with a very difficult situation. The victim and complainant supported the accused for grant of bail. Now in such situation, what court should do? Yes, any of you? Yes, feel free. Whether bail should be granted or bail should not be granted or some other order should be passed. Yes?
Yes, you are free.
Yes, stand up and say feel free. Any other order?
Sir, there should be some relief given to the victim's family and the accused should be kept in the jail. Like that, some order.
Monetary relief.
Yes, monetary relief. Because all she lacked was a monetary relief. She was just appealing for the bail of the accused because she wanted relief for her children.
Children, yes.
Yes.
Yes, Pawde sir.
It's very difficult. You see, he's a earning member, right? You rightly pointed out, suppose he has been released on bail, he will be with the member. There is another chance. Hello, suppose the accused is released on bail. He will be there in the family, and in the family in which he already had committed the rape with his own daughter. How he will come, how they will live, that is the one point. Secondly, if this is the situation, after 5 years again he will come back, that will remain there. That is the second point. Thirdly, suppose he is an earning member, right? He is an earning member. Because he is in jail, his family suffered. So if judiciary cannot from their own fund even can give the directions to government maintain their family. Family can be maintained only by allowing him to the work. So instead of now there are two options, what I say. One option that he may be released but may not be allowed to going home. Right? He may be asked, he should give the maintenance to per month. Otherwise, suppose he has a good case. Lower court may come it because he has come before you in appeal and he might have a better case. And if you don't give the state to the order, then what is the relief? Suppose order is reversed. There is also a chance of reversing the order.
Yes. Now appeal itself could have been decided at that stage.
But that is the point I am telling. If such matter is before you, dispose the matter then and there. Instead of waiting it, keeping it, decide the matter. Don't keep it here for years together. Fix the case for final hearing and decide.
Shrivastava sir.
My understanding is if complainant, the wife herself has withdrawn the basic complaint, right? So basic locus standi of the complaint itself fizzled out, number one. That being so, entertainment of the case itself becomes questionable to the best of my understanding. And henceforth, I think bail can be granted with the condition, as rightly he has mentioned, that some conditions would be imposed in terms of undertaking that he will not visit the family or the house, or he may be barred from entering that particular district where the wife and her family is residing. So some sort of undertaking or some sort of restriction on the movement of this gentleman, in view of the fact that complainant itself stands in a way withdrawn from the complainant, the wife. That is my prima facie understanding.
Madam,
वो बोल रहा है
लेकिन अब मैडम को जाना.
Sir, if evidences are showing the wrong is committed, then according to me, no bail should be granted at all. Because the reason is only he is the earning member. This does not mean that he has a right to sexually abuse a
No,
minor child.
but when we
Yes.
consider all these aspects,
Yes, yes, I'm coming on that.
sufferers are the family
The whole
members.
family is sufferer.
Yes, but that's what I am adding. Again, after this also they are suffering. But if he is coming back to home and if the things are again repeated, again where they will be going, that is also to be taken into consideration. And somewhere, now when we talk about the equality and all other aspects by the women, they should stand strong for their own requirements as well. And this plea that we are dependent on only the male section of the society, somewhere now they should understand that part also. And on the basis of that, I am very firm that they should not be done.
Yes,
बोल
stand and say, mic is not required. You
You are audible.
you have to argue in court.
ये distance रहता है
सबको सुनने आना चाहिए. Yes.
Sorry to say, I'm first year student. I can
So
be
what?
totally wrong.
So what?
So I would suggest that we can appoint a constable for some months or time that he can just take a reading or call him every day to police station to report and just keep an eye on the husband.
So bail can be granted.
If in case it is granted, then
Yes.
in this situation it can be granted.
Yes. Anyone else?
It should not be divided male versus female.
I have heard you. You are with Rohan. Both of you.
So bail may be granted, but there should be a restraining order for the person to not be able to contact the family.
Shrivastava.
Yeah, but in fact, sir,
Yes.
in fact, there is one more dimension, because this crime he might have perpetrated on his daughter, but potential of this man's committing crime on X, Y, or Z in society, that there lies the potential risk, and this is the crime against society. Therefore, bail cannot be granted from that angle.
Yes. Anyone else?
But sir, if it is conclusively proved that the ex-wife is a dependent and cannot
Not ex-wife. Wife.
wife
Wife and daughter, sons.
are dependents and they cannot.
अच्छा ऑनलाइन टीम भी want to answer.
Yes, yes.
Yes, yes.
Am I audible?
Yes. Please.
So, as we support our sir's argument, I would say that, because if he has committed a crime, he should never be released. But as we know this code that Atmanirbhar Bharat, she should be provided with some sort of, occupation or some sort of work that she can do to earn herself a living, and she can, fulfill the needs of the family instead.
Yes, sir. Thank you. Anyone else? I don't know whether we were right or wrong, but we passed an order, as Rohan said. There is a provision in CRPC, I think section 357 or 457.
357.
which casts an obligation on the government to provide compensation to the victim. It is, I think, called Victim Compensation Fund or something like that. No, no, not legal service. No, it depends. So relying on that, we passed an order, rejected the bail application, and passed an order directing government to pay some fixed amount to the victim daughter till the accused is released. Till that time, that amount should be paid every month as compensation. That was the order.
Just like a maintenance order.
Yes, and there is provision in CRPC, and there are judgments of Apex Court. They are very nice judgments. The Apex Court has said that it is a long time that these provisions are brought on the statute book, but they are not being implemented. They have issued directions to ensure implementation of those provisions. You go through that judgment.
Victims compensation. Huh?
Victims compensation, yes. Earlier, such provision was not there. It is by way of an amendment it is brought on the statute. Then other similar case, if you are interested.
Yes, sir.
A minor girl had an affair with a boy who was major. But as they wanted to marry, but as the girl was minor, it was not possible to perform marriage. Relations developed. Girl gave birth to a child. Still she was minor, below 18. Parents of the girl lodged complaint. That boy was tried, convicted. He was in jail. His appeal and bail application came before us. There, the mother of girl was minor, so mother represented the girl. She filed an affidavit that there are no objection for grant of bail provided the boy marries the girl. So by the time matter came before us, that she had attained, she became major. There was an affidavit by mother of the boy that yes, boy is willing to marry the girl. Now, crime was committed. Sexual intercourse with minor, even with consent, is a crime. So, crime was committed, no dispute about it. Child was born when she was minor. My brother said, how can we pass such an order that if he marries, we will acquit him? I said, we cannot pass such an order acquitting him. So then we will reject the bail application. I said, no, we will keep it pending and we will see if they marry. We said, okay, take your proposal further, work it out amongst yourselves. We passed necessary orders to enable both of them to have meetings in jail. Then joint affidavits came that marriage can be performed. Again my brother said that no, we cannot pass such an order. But I prevailed over him and I said we will grant him bail, but only after marriage is performed. Marriage should be performed in jail. All rights should be performed there. and then we will grant conditional bail that it will be for 1 year, and then after 1 year they will report back to the court, and if court feels it that bail order may be continued. And we kept the appeal pending, and we directed that appeals should be listed in normal course, which normally in high courts happens after 15 to 20 years. So they married, and then report came that they are happily living together. These instances I am pointing out to you to make it clear that criminal law does not mean grant of bail, refusal of bail, conviction, acquittal. These are not the only things. In criminal law also there is how justice should be administered to the victim, to the complainant, to the accused, that can be examined and should be examined. Now, you might have already prepared the matter which you have to argue in moot court, but you can develop further arguments keeping in mind all these aspects. When Shwetal and Amruta came, I said that there are many issues which can be raised in PILs, as Pawde sir suggested. Just that day it clicked to me, and I told them that you can do some research and file PIL. Challenging the packaging of products in our market. We have pastes, we have soaps, we have many products which are already packed, and then there is another packaging box. That additional packaging box is not at all required, and in some developed countries which are very sensitive to environmental issues, this I am saying because fortunately we have Mr. Shrivastava with us. Countries which are very sensitive on environmental issues, they don't permit such packaging. If the tube of paste is to be sold, it is not kept in a box. It is just tube. Cosmetics, only tubes, no boxes. And for those boxes, we are paying, consumers are paying. Consumers are charged even for those boxes. And above all, the wastage of natural resources. Lakhs and crores of trees are cut down for this packaging material. So some of you can try such PIL, initially make a representation to the government, to Mr. Shrivastava also, copy to Mr. Shrivastava for necessary action, and then file PIL. There are many such issues. We are not attentive about these things, about drinking water. I don't know what is the position in Nagpur about the treatment plants, STPs. I don't think they are functional. We are not getting safe drinking water also. So these are the things which our budding generation will attend to. We have failed in these things, but we look upon you to ensure that you are not failures as we have been. With this, I complete today's session. Wish you all the best and thank you very much. Pawde sir wants me to declare that the Kshan program,
Kshan Moot Court competition.
Kshan Moot National Moot Court competition is open, but it goes without saying. Wish you all the best. How many teams are participating this time?
12.
All the best to all of you. And fact that you are here is shows that you are a winner. All of you are winner. All the best to all of you, and not only for this program but in your future life and profession also. Good day.
Finally, for concluding, thank you, sir. Finally, for concluding, I would like to ask our General Secretary, Mr. Sudhanshu Rodkar, to deliver the formal vote of thanks.
Thank the other way. The most urgent duty is that of preparing. I take it a great honor and privilege to propose the vote of thanks on this occasion. I would like to thank our Chief Guest, Honorable Justice Haq Sir, for gracing this occasion and event and inviting us to great zeal and enthusiasm. I extend my most humble gratitude and thanks. Thanks to our guest of honor, Dr. Praveen Shrivastava sir, for gracing the event and giving it a wonderful head start. I thank Dr. Ashok Pawde sir and Dr. Sona ma'am for guiding us throughout the preparation days. Last but not the least, I thank all the Moot Court Association members, students, teaching and non-teaching staff for their valuable inputs. Once again, a huge thank you to all of you. Thank you.
Just one more thing I want to share with you when Mr. Shrivastava is here. It is better to strike when the iron is hot. About 20 years ago, I had gone to Supreme Court to attend some matter. After I finished the matter, there was rush in one particular court. That time we were having green bench. Justice Kuldeep Singh was heading that bench, and our environmental matters were before that bench. Court was full, so naturally I also felt that I should sit in that courtroom. Someone was arguing, perhaps he was not a lawyer, he was a subject expert, matter related to environment, cutting of forests for the so-called sustainable development. But those arguments, still I remember, the argument on behalf of government was that, sir, we have cut about 5,000 trees, which normally is the argument even in that Mumbai motor shed matter or something like that. We have cut down 5,000 trees, we are planting 1 lakh trees, we are compensating the nature. Those were the arguments, and the facts and figures were supplied, judges were convinced. But when that expert started arguing, it was fantastic. He said, you are not compensating the nature. In that area, particular types of trees were growing. You are planting trees of your choice, not the trees which were growing in that particular area. And environment depends not only on the number of trees, the type of trees. and the shrubs which grow in the shade of those trees, the smaller plants which grow near those trees, the birds which come on those trees for the fruits of those trees, the what they call pollination, no, the birds transport the grains. What? Pollination.
Yes.
Because those particular types of birds come on those trees, the pollination takes place. So planting 1 lakh trees in place of 5,000 trees is not the solution. I remember this when I was talking to Mr. Shrivastava. So these are the issues which are required to be examined. We are happy that yes, government has cut down 1,000 trees, they are planting 50,000 trees, they are compensating the nature. That is not compensating the nature. So keep all these things in mind because future litigation will be relating to all these aspects only. Thank you.
Right. In fact, sir has. Can I get a mic?
You can. They are hearing you.
In fact, I am really so impressed with the remarks of Honorable Justice Shri. And let me tell you very frankly, I 100% endorse whatever he has said. Because, one, biodiversity cannot be created by a human being.
Human being, that is the point.
Okay? We call it compensatory afforestation. Okay? Let my statement not be misquoted or misunderstood. But frankly speaking, any person with scientific temper will agree that a forest land cannot be recreated because, as very aptly and very rightly he has put, it is not mere trees. It is sum total of soil, groundwater, surface water, herbs, shrubs, climbers, birds, and so many species put together.
Butterflies.
Yes, at a point of time, prior to the destruction or felling of the trees, that pre-felling phase cannot be recreated at any point of time later. That is the truth. And I hold no compunctions in conceding to the fact that it is true we did carry out plantation, forest department did carry out plantation. That may have made some marginal impact on the improvement of environment. But having said that, construing that plantation effort as a substitute to compensate fully for biodiversity restoration would not be a well-meaning statement. So I fully agree, and that is the truth of life. And maybe a year from now, I also start practicing with you people. And yes, this shall always be an issue of concern and should be an issue of concern for all of you. Thank you so much.
Thank you, sir. Thank you.
Thank you, sir. We are at the end of inaugural event. It is a request to the teams to note that the orientation will start at 5 o'clock sharp. The researchers and the speakers join the orientation link first, and within 15 minutes of the orientation, another link has to be joined by the researchers, which has already been provided to the team coordinators. If anybody has any queries, kindly put the queries to the team coordinators and they will be addressed as soon as possible. Thank you.
Thank you so much.
Thank you.
All the best.
Students the hall, students don't have the facility of having a break, it is only for the teams. Fine, you can have a 15 minutes break. Each one of you needs